First order of business is to do the roll call. So I'm going to call the roll, and if you could please, even going forward, identify yourself after the roll call. Identify yourself when you're speaking, so that the public knows who's speaking when you speak, and then speak. That would be helpful. And if you could keep your microphone muted when you're not talking, that would also be very helpful. So with that, let's get started. Is Justice Eckert here?
Yes, I am.
Okay. Judge Goodrow?
Yes, here. Thank you.
Judge Massicott?
Yes, I'm present.
Judge Morgan?
Here.
Judge Prescott?
Here.
Judge Sheldon?
Here.
Attorney Edelman?
Here.
Attorney Bourne?
Here.
Attorney Cunningham?
Good afternoon, here.
Attorney Gaylor?
Present.
Attorney Goulash? Here. Okay. Attorney Steigelfast?
Here.
And do we have Professor Simon Kerr joining us?
Yes, here.
Okay, great. Okay. Next order of business is the approval of the minutes from our March 1st meeting. Excuse me. Do I have a motion to approve the minutes?
So moved. So moved.
So I didn't catch who that was. Did you, Lori?
Mr. Gaylor, I saw.
We'll attribute it to Mr. Gaylor. Do we have a second?
Good roast.
Any discussion on the minutes? Seeing none, those can be unanimously approved.
Justice Mullins, I'm going to abstain. I wasn't at the meeting on March 1st. This is Judge Morgan.
Judge Morgan, okay, great.
I'm in that group as well. Thank you.
Yes.
This is Judge Eckert.
Okay. So now we'll move on to item 2 on the agenda, the old business and the revisions to the amendment to the code, section 7-3. You should have all received the marked up version. The original came out on March 1st. We had discussion. After those discussions, Judge Prescott and Attorney Steigelfast took the comments into consideration. And what you have now is the proposal that we send to the Supreme Court for approval that would show up in the Code of Evidence book. So do we have a motion to approve the amendments to section 7-3 of the code?
This is Judge Sheldon. I'll move its approval.
Do we have a second?
Judge Morgan, second.
And now for any discussion.
Eric Levine. I had a couple of very technical things, but I don't know if that should be addressed after the fact or whether I should address them now before the committee. They are very minor things. They are punctuation or capitalization or spacing issues.
Why don't you tell us now, Eric?
Sure. I was going to suggest in the rule itself, subsection A, right before subdivision 2, and before the word "and," there should be either a comma or a semicolon there. On line, I guess this will be the second page, first full paragraph right after the citation, id 132, note 2. Apparently a period was actually deleted.
Clean it up and send it to the reporter's office, for a final look with the permission of Justice Mullins.
Sure. Those don't seem like substantive amendments, but does anyone have either any comment on those or discussion on anything else regarding the substance?
Justice Mullins, I had one question. I'm not certain of where it ends up or whether it should end up anywhere, but it's on a different point though than those raised by Eric.
Okay.
Is that okay? Yeah.
Yeah, I think those are pretty technical.
In that paragraph that's in the commentary, so it starts section 8.2 recognizes an exception, etc. 1, 2, 3, 4, 5 lines in. It says that portrays an event relevant to the case, and I don't know if I know people put a lot of time into these, and I'm sort of coming in as a spectator after the point, but I don't think it'll cause any mischief, but I'm not sure that an event is the only thing that can be portrayed in a photograph. But I don't know if I was trying to think of a better word. And it could be any matter or any item or something, and maybe somebody else has a better idea, or maybe it's not a problem. I thought I'd raise it. In other words, the guy's walking down the street and there's a video of his face, and it's about identification, and it's not really about the shooting in the nightclub.
And you think event wouldn't cover that?
Well, I don't know if that's an event.
Mm-hmm.
I mean, maybe it is.
Yeah, and I'll open it up for discussion if anyone sees something different. Attorney Edelman?
You could substitute the word something for the 2 words an event.
I like the colloquialism of Attorney Edelman's suggestion, but others may not. It could be, as an alternative to that, it could be anything.
Can I suggest?
Judge Morgan.
Yep.
Judge Morgan.
How about instead of an event, the words a fact?
Oh, that's nice.
Eric Levine, I was just wondering whether event or anything would be under inclusive, because are we talking about covering a photograph of an individual or persons, which wouldn't necessarily be covered by the word thing?
Well, people are things, Eric. But no, I agree. I think fact takes care of that problem, doesn't it? Right? I mean, unless this would apply to anything. Do you have a problem with fact, Eric?
No, not necessarily. I just want to make sure we're covering all our bases with the word that's ultimately used.
So if I may point out, however, that the footnote used by the court uses the word event. And I'm not sure if we're changing the meaning in any way by using fact rather than event. But that footnote 2 says depicted an event relevant to the case.
I'll just point out that was Judge Massacott speaking.
Oh, my apologies. Okay. Thank you.
It's okay. That's why I get the big bucks.
And I'll just point out that was Justice Mullins who wrote that footnote too. But no, and that's exactly why I felt a little timid walking into this thing, because I was quite sure that there are reasons behind the word choice here, if maybe it's more important to stick with the language of the opinion than it is to change, have a slightly different word in there that's maybe a little more expansive. But I'm not one to, that's not up to me, I guess. I don't know
Well,
what you think.
Well, I guess it's up to all of us, and I don't want to be heavy-handed, but I thought the guy who wrote event got it right. So we should discuss it as a committee, because this is the commentary, which could illuminate the rule a little more. It usually does. So I think event is okay, but is your hand still up, Judge Morgan? Okay.
It is. Because it's the language directly out of the footnote, I think we should
This is
leave the
Judge Sheldon.
language. This is Judge Morgan. I think we should leave the language exactly as it is in the footnote, because to do otherwise would lead some to believe that we were trying to imply something that isn't there. If you just quote exactly the language in the footnote, it shouldn't lead to any confusion.
Did you want to add to that, Judge Sheldon?
Yeah, I mean, I think the point's well taken. That event suggests something that's discrete and has an internal or intrinsic significance. Whereas, I mean, think classic example comes to my mind is the photographs that get taken who are on the street at a given point in time. Someone walking by a camera. I mean, if you ever watch a British television show, they're all over the place, right? We have fewer of them, but we still have those things. There's no particular event involved. So if the event was subject to a general construction, I think that there has to be some intrinsic significance to the thing that's being photographed, apart from the photograph itself, and that's the problem, or that could be the problem. And I'm wondering if there's a broader word to use. The court could always interpret it itself. It says this is a rule of the court's own creation. I'm not so worried about being bound by language in the same sense as when this committee was a committee of the Superior Court. The Supreme Court has the power to pass these rules, regardless of what the common law says.
Well, it's an interesting question. I mean, Justice Mullins and I have talked about it occasionally about what the role of, the committee is, and I'm sure everybody's thought about it, and what our own roles are, and so forth. And if all we're doing here is sort of repeating in haec verba the holding of the court. I mean, it's dangerous to say anything. We can just say, we can cite we can quote it, and we should use quotes and not put anything in our language. If there's any sort of independent role of this committee, not in expansion or contraction, but in clarification, I would say, then I don't think we're bound to that language. But again, that's just one person's view.
In that I'm sorry, Judge Mascott, go ahead.
I'm happy to wait. Please, go ahead.
We could, instead of changing the language, we could take some of the language out and just remove the phrase that portrays an event. So it says applies to any type of video recording or photograph relevant to the case.
That's good.
I like that too. We should put Judge Morgan on the, she should be on the committee. I guess she is on the committee.
I'm sorry.
Judge Massacott.
Thank you. Though the only thing that concerns me about that and eliminating the word event is that this is an exception to the general rule that if it embraces an ultimate issue, a lay person can't testify. And the identification of somebody isn't necessarily the ultimate issue, although it may be relevant. So for example, in the case that we're relying on, the Gore case, or what is it, State versus Gore, in any event, they accepted the evidence because it was related to the ultimate issue, not just the identity of a person, but the identity of a person who committed the crime. And the depiction was of that event. So that's the only thing that causes me a little concern with making it broader. We may be going beyond what the Supreme Court meant there.
Maybe we could say video recording or photograph admissible under Gore or other, I mean, I think your point is well taken, that we don't want to suggest a different standard of admissibility here that suggests that, well, if it's relevant, it's admissible. But I'm not sure that point goes to whether we use the word event or fact or something else.
I don't want to put either Attorney Staglefast or Judge Prescott on the hot seat, but you guys did work on this and came up with the edits to our original version. So I do want to open it up to you guys if you do have any thoughts on this particular point of conversation.
Jack Steigelfest here. All I would say about that language is that it pre-existed our edits, but if it were up to me, I would just put a period after the word paragraph and say the holding is not limited to surveillance video, rather applies to any type of video recording or photographs, period. Then you're just relying on the holding of Gore. You're just leaving it up to whatever type of evidence that you're talking about, and you don't have to get into the rest of it.
We lose Judge Prescott.
No, I'm here. I'm comfortable. Okay. I'm comfortable with Jack's suggestion.
There's a few suggestions on the floor. That's the latest one. Are people okay with a period after photograph? And then I presume yes. Still cite to 132 note 2 in Gore.
Yes.
Good by me.
Same with me. Fine. That's Judge Morgan.
Judge Morgan. Judge Massacott, you had a few thoughts. Would that be acceptable to you?
Yes, thank you.
Okay, so I will propose a motion with that amendment. To be honest with you, I'm not really sure what to do with Eric's amendments. They seem hyper technical. That would just come out in the wash. So
yeah, I don't think we need a vote on any technical amendments. That's kind of within the purview of the reporter's office to, site check, etc.
Yeah, that makes sense to me. So I'll move that we approve the edits to section 7-3, and the amendment would be that in the paragraph starting subsection A2 in the commentary, the second sentence, the holding is not limited to surveillance video, but rather applies to any type of video recording or photograph, period. We would delete the rest of that sentence, but still cite Gore id 132 note 2. With that amendment, we have a motion to approve the amendments to 7-3.
So move, Judge Morgan.
Judge Morgan, do we have a second?
Second, Judge Sheldon.
Okay. All in favor? Aye.
Aye.
Raise your hand.
Aye.
Yes.
Excellent. Okay, the amendment passes. So from this point
Justice, I'm sorry,
yes.
Justice Mullins.
Sure.
Just for formality, could you just ask if there's anybody who opposes?
Oh, yes. Does anyone oppose? Any abstentions? Seeing none, now we're good. Now motion passes. So at this point, what I will do is get this on the Supreme Court's calendar for the Supreme Court to approve. I don't think we need to go through the process we went through before with the business records exception, because this is really mostly just codifying gore. So this should be relatively quick. We did have the electronic version uploaded. And if you remember from last meeting, we spoke with Eric. We can get a new book out with this amendment in the new book. Eric, if we're not off track, this still could happen within a couple months. Does that sound right?
Yeah, definitely.
Okay, so I will make sure to get this on our calendar and get it approved. And we will get a new Code of Evidence book out within a couple months.
Great.
All right, I don't have anything else on the agenda, but I certainly would open it up if there's anything else any of the members want to discuss.
Just small, just very, very briefly, I
Sure.
just wanted to say it was great to see everybody. I wasn't here at the last meeting, but it's really good to see everyone, or at least whoever is appearing on the screen. A special hello to Judge Sheldon. It's so nice to see you. I don't know if you're in the same moving vehicle as Jack Steigelfest, and that's probably none of my business, but it looks like you guys could be passenger and driver. I don't know. Maybe not. So I just wanted to say hello to everybody.
Thank you. It is nice to see everyone. At some point, we'll be back in person, hopefully. Hopefully that's a good thing for most people, but I think it would be good for us to get back in person. We don't have anything immediately on the agenda or that we need to discuss. But certainly, as things arise and things come up, feel free to let me know, and we can have a meeting to address them. So with that, do we have a motion to adjourn the meeting? Attorney Edelman, you looked very excited for the adjourning the meeting portion of the meeting.
I make a motion to adjourn the meeting, and I look forward to meeting in person with all of you at some point.
Great. Do we have a second?
Second, Judge Morgan.
Okay, so with that, we are adjourned, and look forward to the new book. And I'll keep you updated on the happenings at the Supreme Court.
Bye, everybody.
Okay,
Thank you.
bye-bye.
Thank you. Bye.
Thank you.